everyone. I'm Richard Meeran, the head of the International Department at Leigh. Welcome to our discussion this afternoon with Joe Fiorante QC on corporate accountability cases in Canada. I'm pleased to say that we've got over 200, well over 200 people joining us from around the world for this event. Now, in recent months, we've held webinars on the current state of play in multinational human rights cases in various multinational home states. Back in July, we heard about developments and issues in the UK, Netherlands, France, and Germany from practitioners who have been at the forefront of litigating those cases. And considerable progress has been made using a tort-based parent company duty of care in the UK. That's culminating in the 2019 Vedanta judgment. And in January, of course, we had a very important decision from the Court of Appeal in the Netherlands in a case against Shell, holding the parent company liable for damage caused by oil leaks in the Niger Delta. And then in December, we heard from Paul Hoffman about the Alien Tort Statute cases in the US, which after much initial promise back in the 2000s, suffered a series of setbacks since the Kiobel decision in 2013, although we're hoping that the impending Nestle decision from the US Supreme Courts may get things back on track. And there's also been important progress in Canada, which is what we're going to discuss today. Canada, home to mining companies that have been associated with human rights violations in various countries. And in particular, we've had the Hudbay Minerals case in 2013, and I believe that Corey Wanless, who was the lawyer in that case, is with us today. There's also been the cases of Garcia and Tahoe in 2017, and in February last year, 2020, we had the landmark decision of the Canadian Supreme Court in the Nevsun case. No doubt due to the similarities in the law and the nature of overseas multinational operations, there is a considerable degree of overlap between the Canadian and UK cases in terms of the facts of the cases, the legal bases of the claims, jurisdictional challenges, for example, on the basis of forum non-convenience and act of state immunities, and procedural issues around access to documents and class actions, and important practical questions around funding and legal representation. And hopefully our discussion today will elicit some of these commonalities and differences. One of the differences that stands out, of course, is the decision in Nevsun on the direct application of customary international law against a corporation alleged to have been complicit in fundamental human rights violations. Joe Fiorante is a partner at Vancouver-based Camp Fiorante, Matthews and Mogerman, from where he has handled transnational aviation, tort and human rights cases from a diverse range of jurisdictions, including Guatemala, New Caledonia, Mexico, Germany, and the Republic of the Maldives. Most significantly, in the context of today's discussion, Joe acted for the plaintiffs in the Garcia and Nevsun cases. Joe, thank you very much for agreeing to speak to us today. We're very honored and delighted to have you here with us. And as I said at the beginning, you've pulled a very big crowd, which is very good.
Well, thank you. I think most of them are colleagues from the Nevsun case, but we'll ignore that for now. But thank you, Richard. Yeah, this is a real honor to be here and to a chance to thank you and your team for work that we borrowed heavily from in both Garcia and in Nevsun. So I'm looking forward to it.
Great. Joe, maybe we could just start with just a few brief background issues. I mean, first of all, about you and your firm. I think I'm right in saying that probably like us many years ago, where you came from was a tort litigation background rather than a human rights background, and that you've gradually broken into this important work.
Yeah, absolutely, Richard. We came from a tort background and a class action background when class action proceedings were introduced to Canada in the early 1990s. We, my partners took on some of the early class actions, and we built up some familiarity with it. We had always been a plaintiff's contingency fee firm, and I raised that only that we were, we were a risk-taking firm in the sense that most of our complex tort work and all of our class action work was done on a contingency basis. So we developed maybe an unhealthy appetite for risky cases, but that is how the international human rights cases found us, not the other way around. And colleagues at NGOs, Matt Eisenbrandt, who was at Canadian Centre for International Justice at the time, approached us to take on what became the Tahoe case in Guatemala. And as it turned out, I had a bit of a personal connection to Guatemala, having spent some time there in the early 1990s, and then through being on the board of a very small Vancouver charity that was building a village for abused mothers and children. So it's a place that I had a personal connection to. And when Matt came calling and described the case, we decided it was something that we should take a very serious look at, and that's how we got started. But none of us were human rights lawyers. None of us even really educated in international law in any other than in the cross-border forum non-convenience issues. But certainly we did not have any expertise in customary international law when we started down this path.
Well, I think I can certainly identify with that that kind of development. I think for us as lawyers who started off doing tort cases, we weren't really recognised as human rights lawyers back then, and we didn't see ourselves as that probably at the beginning. But there's certainly been a convergence, hasn't there, between tort law and human rights law. And I think those of us that have had the privilege of working in this area, have really, not only been involved in developing the law, but gained a lot of satisfaction from it.
Yeah, absolutely. And I think, looking back, I think our experience in tort law was incredibly valuable because we knew and lived the limitations of it. And when we were looking at Garcia and really Nevsun plotting a course, we recognized the value of customary international law in dealing with some of the really profound deficiencies in Canadian tort law that I'm sure we'll get into. But from the outset, I can say on Nevsun, we were very concerned about choice of law and the relentless argument that conduct that occurred in Eritrea must be governed by Eritrean law. And one of the main reasons we started to really look at customary international law was to avoid that, really what I think is a trap, and what I think I've always thought is a really outdated way of thinking, that this is a binary problem rather than a transnational problem. And so we were very much went in search of customary international law to establish a transnational norm of conduct that we could invoke and essentially not just overcome, but override this binary choice of law problem. So yeah, coming from a tort background proved to be very useful because we were really familiar with the problems we were about to encounter. So,
and as you say, of course, having done cases on a contingency basis, very aware of the practical issues that you have to face litigating these kinds of cases, the risks, the cash flow risks, the resources, and so on that you need to muster,
Yes,
especially against well-armed defendants.
exactly.
Yeah. Well, perhaps we can just talk about some of the principles that emerge from the multinational cases, and we perhaps go through them one by one. The starting point is the jurisdiction of the Canadian courts in these cases. Now, I mean, in the three cases that we've discussed, the Hudbay case, the Tahoe case, and the Nevsun case, we're talking about Canadian parent companies as the defendants. So presumably the key point there is the defendants are domiciled there, or domiciled in British Columbia in two of the cases, and in Toronto in the other case, which is why it was possible to bring the claims in those courts.
Yes, yeah, exactly. I don't know if the statistic has changed, but it was recently as many as 60% of the world's mining companies are domiciled in Canada, and they tend to be at the junior mining end of the scale, not necessarily the large multinational mining companies, but many of the exploration and junior companies start in Canada because they have access to a very efficient capital market in Vancouver and Toronto. So yes, in the case of Hudbay, Tahoe, and Nevsun, they're all domiciled in Canada. Hudbay, as you say, in Ontario, Nevsun and Tahoe in Vancouver. Although Tahoe is again, kind of a paradigm case in that the head office was located in Vancouver and was not much more than a mail drop. The operational nerve center was in Nevada, and the mine was in Guatemala. Now, the other feature of those three cases, at least initially, is these were single asset companies. Tahoe, the only mine they had was the one at in San Rafael Los Flores in Guatemala. Nevsun, when we started the case, the only mine they had was the Bisha mine in Eritrea. And Corey Wanless will jump in if I get this wrong, but I believe at the time, Hudbay's principal mine was the El Astor mine in Guatemala. So the corporate chain is pretty straightforward, which turns out to be valuable to us.
Yeah, it makes it so to say easier. It's obviously very difficult, but the connection and issues like control and so on are going to be a bit easier in that kind of situation.
Absolutely.
Now, I mean, what I noticed as well in these cases is that you only sued, or in all three of these cases, it was only the Canadian parent that was sued. Is that because you can't join the subsidiary companies, or was it because there was a concern that by bringing in the subsidiary, you might increase the risk of a forum non-convenience challenge?
Yeah. Yeah, it is definitely the latter, Richard. I believe we would have a powerful argument to implead them if we needed to under our flexible approach to, transnational jurisdiction in a case like this with an absolute anchor defendant in a Canadian company. We could add other necessary parties, but it was really the risk of forum non-convenience. And, at the time we started Garcia, I would say in our firm, a deeply rooted fear of forum non-convenience, because the cases that had come before us, other than Hudbay, had been dismissed on jurisdictional challenges. And so we were acutely aware of that history, and we made a very conscious decision to sue only the Canadian parent company, and then to borrow very heavily, Richard, from UK precedent, especially Chandler and the asbestos cases, in anchoring the case against the Canadian company. And I guess I would say the other reason we did that is we recognized, as a matter of advocacy, that we needed to persuade the court that this was a Canadian problem and to center it on the decision makers in Canada, because the concern was that this would be regarded as a in the Garcia case, the circumstances were that the security team from the mine broke up a protest by opening fire on our clients. And I think we were gravely concerned that the court would perceive it as pardon my language, but an ordinary event of Latin American mining violence that had very little to do with Canada and ought to be sorted out by the Guatemalan authorities. And our instincts proved right. We were dismissed on forum nonconvenience in the first instance in the Tahoe case in a perhaps one of the worst and least effective hearings of my advocacy career, where the judge was just simply having none of it, had no interest in engaging in the Canadian element, and very quickly decided that it was a Guatemalan problem. So fortunately, we were able to overcome that. But I think our instinct was correct. Had we named the Guatemalan subsidiary, we would have been out the door in record time. So
I think that certainly resonates with me. It was part of our strategy in the early years. Of course, in 2005, because of the clarification of the position under European law,
yes,
which precluded European courts from declining jurisdiction on that basis when they were dealing with a home domicile defendant. We haven't really faced forum nonconvenience, but certainly prior to then, it was a major challenge. And I mean, the point in these cases, it's all very well arguing about the most convenient forum when you're two commercial entities fighting each other, and it's just a question of
exactly
where you're going to get the best deal. But in our cases, Joe, I mean, obviously in these cases, it's you get justice in the home courts or not at all.
Precisely, and I think that one of the profound disappointments of losing Garcia in the first instance was the really disappointing lack of engagement by the bench, in that if you were to canvass anyone who wasn't a lawyer, who had any experience in Guatemala, and ask them if there's a functioning system capable of delivering justice and upheld by the rule of law in Guatemala, people would simply just laugh that was conceivable. I mean, Guatemala has an incredibly tragic history, and if people could get justice through the rule of law, it would not look anything like what it has for the last 500 years. So we were profoundly disappointed by the court's lack of interest in really systemic barriers to access to justice in Guatemala, corruption amongst the judiciary, the relentless struggle by lawyers in Guatemala to try and impose some semblance of the rule of law on powerful actors, and the ease with which our lower court dismissed the case, as you can tell, still bothers me greatly.
Yeah. And what was heartening, though, is in the higher courts and in the other cases that the Canadian courts didn't shy away from concluding that the plaintiffs wouldn't receive a fair trial in Guatemala or in Eritrea, including due to bias and corruption.
Right, and I think in Garcia we got, I won't say we got lucky, because the events played out exactly as one would expect. In that case, the architect of the shooting of our clients was an individual named Alberto Rotundo, who was an ex-Peruvian Special Forces officer who had been brought in specifically by Tahoe to run security operations at the mine. And it was Rotundo who ordered the shooting. And he was, at the time of the first hearing before the BC court, taken into custody and under house arrest. And then events played out as they always do in Guatemala. By the time we got to the Court of Appeal, Rotundo had literally walked out of house arrest, across the border to Honduras, and taken a plane back to Peru, where he really quite brilliantly for us sent an email to the prosecutor saying that he would now defend himself to the full extent of his Peruvian constitutional rights, and basically, telling them what they could do with their criminal prosecution in Guatemala. So that, that event essentially gave us a hearing de novo in the British Columbia Court of Appeal. There was no need to give any deference to the lower court, but it demonstrated precisely the issue that the lower court had failed to engage with, which is that there was never going to be justice for these protesters through the Guatemalan system. So, and I think that was as I said, I can't call it a stroke of luck, because it played out precisely as it always does in Guatemala, where powerful actors escape any responsibility for their conduct, and still have escaped it. So,
well, we've done a couple of cases where the facts are remarkably similar, actually, for communities in Peru, where following environmental or during environmental protests, because of there's been ongoing historical disputes between the communities and the mine about the existence of the mine and the mining operations. The mine has its security and sometimes calls in the police, and people are beaten and shot and sometimes killed and tortured. And what happened in the two cases we were involved in, one against Monterrico Metals and another against Extrata, was that it was the protesters who were prosecuted for various public order offences, some terrorism offences actually, but no action was taken against the company or the police. So the idea that people in that situation would have any realistic prospect of bringing claims in their local courts is
right.
It's just zero, isn't it?
Yeah, and and in our Nevsun matter, we spent 26 days in oral argument in chambers on preliminary challenges, including forum nonconvenience, and we were treated to a delightful description of the functioning union system, the robust legal system in Eritrea, and how it was, how they had a functioning system of justice, which we countered in every conceivable way. But the most powerful way we countered it was by judges who were in exile, who had fled and were in Western Europe and in the United States, who recounted what it meant to be a judge in Eritrea and have the military come into the case in the middle of trial and remove someone, never to be seen again. And in one instance, remove a judge, never to be seen again. So I could tell you the evidence that a judge had been forcibly removed from a courtroom by the military and disappeared resonated with the lower court in British Columbia. Pardon me. But I thought that in the lower court argument, Justice Abreu was quick to get to these points, and he posed a profoundly obvious but important question, which was, well then, if the system of justice in Eritrea is so powerful, you will of course show me examples of how individuals have been able to vindicate their human rights in like situations. And you can of course list those cases for me, which is met by profound and deafening silence, right? So it's a really important point that there are no cases in which justice is achieved in that way, and that speaks volumes.
Yeah. Now, in the UK, as a result of some cases we did many years ago, there's now a principle that has been introduced into forum nonconvenience law that a stay will be refused, even where the local courts are the more appropriate forum, if the claimant could not get substantial justice in the local courts due to inability to obtain funding for legal representation and experts. That was a very important factor in the cases that we did, and some of our more recent cases. I don't know. My understanding is that isn't part of Canadian law. Is that right?
Well, we certainly argued that point based on your precedent, Richard. So again, thank you. But it did not become a point of decision in our cases because the court didn't need to go that far. I mean, Eritrea is, the choice was so stark in that case that we didn't need to go that far to make the point. But we certainly argued it, and I would not hesitate from arguing that precise point in the next case, should that be necessary. I think, and I think the hope that we all have between Corey Wanless's work on Hudbay and Tahoe and Nevsun, we've changed the narrative around how these cases are perceived. And one of the points we made is it's that these corporations are creatures of the Canadian legal system. It's where they're given life, but they also raise capital very efficiently through a complex legal system that gives their investors incredible rights. And yet, to suggest that they can't be held to account here because of their conduct overseas always struck me as completely incongruent. And so we've been really trying to push the narrative with the court and to educate them that these are Canadian problems that are best addressed here, and hopefully we've had that effect. I mean, the result of Tahoe and Nevsun is that now we're in the situation where we have jurisdiction over resident corporations, and that jurisdiction will be maintained absent the defendant showing that the other form can deliver justice more fairly. So that's a pretty high standard now. So we're feeling comfortable that we've now laid the foundation for these cases that the next ones that come, there will not be 20 days spent on preliminary challenges over these issues, hopefully.
Well, certainly we'll come to it in a moment, but the Nevsun Supreme Court decision gives a very clear message, doesn't it, to the Canadian courts about how they ought to be viewing these types of cases.
Yeah, we certainly hope so. And, that was the facts of both cases are, I suppose, as you say, if you haven't done any of these cases, the facts seem rather egregious and extreme. Unfortunately, they're also very commonplace in the communities where these mines are based and where there's opposition to the mine. As you said, the circumstances of the Tahoe case seem quite extreme, and yet they're repeated throughout Central and South America.
Exactly. Now, you mentioned earlier on the difficulties that you can encounter when dealing with the choice of law questions that arise in these cases, and we'll come on to the position in Nevsun and the customary international law claims. But I mean, generally, my understanding is that the basic rule in Canada is choice of law rule is that the law in a tort case, it's the law of the place where the commission of the tort occurred that generally applies. Now, in our UK cases, and they've been the Vedanta case and so on, they've been considered under English law and principles of English law and duty of care and so on. That's because the places where the harm occurred happen to be former British colonies, which have English-based systems of law, and so English law essentially applied. But what I didn't quite understand is in these three cases that we're talking about, which were two in Guatemala and one in Eritrea, that they all seemed to, when it came to the tort claims, had been based on English law. There's a reference in the Hudbay case to, I think, the Guatemalan civil code is appended, but the contention is that Canadian law applies. Sorry, did I say English law? I meant Canadian law. Canadian law seems to have been assumed to, or certainly as the allegations are based on Canadian law.
So we certainly asserted that. I think in Tahoe, our concern was that was not so much that there wasn't a civil remedy in Guatemala for an assault. It's that it's that the remedy wouldn't capture the conduct of Tahoe itself as the parent company. So there was no ability to pursue that claim as a matter of Guatemalan law against the parent company. And as I recall, there were some complex issues around Mr. Rotundo was not actually an employee of the parent company, or as I recall, the subsidiary company. He was employed under something called a contrato, or some sort of contractual arrangement that made questions of vicarious liability very challenging under Guatemalan law. So it wasn't so much that you couldn't sue someone for shooting you. It was the subsidiary problems around linking of corporate accountability for that act that we were concerned about. But again, there was considerable evidence on choice of law, and to your point, adding considerable expense to the case because we retained Guatemalan experts, and of course the defendants had the equivalent of a Guatemalan white shoe firm provide extensive analysis on Guatemalan law. But in our forum nonconvenience test, the court has to only consider the choice of law issue as a factor to weigh, but it doesn't resolve the choice of law issue at that stage of the case. So that's why we never got to the actual finding as to which law would apply. But Richard, again, to your point, it essentially means you're litigating choice of law twice in the case with expensive expert evidence and the need to call that evidence in affidavit form or perhaps at trial in viva voce testimony. So, yeah.
What about damages? Would that be assessed in accordance with local law or Canadian law in these cases?
Yeah, it's an excellent question. I mean, in theory, if we lost the issue of choice of law and Guatemalan law to apply, the Canadian court would apply the principles of Guatemalan law. But it's unclear whether the court would have reference to Guatemalan cases to have a guide on quantum. So that issue we never got to the end point of. Right. Corey is still litigating the Hudbay case through to trial, so he may have some information for us on where they're at on their choice of law fight. Okay. Guatemalan law.
And in these three cases now, you had the corporate veil issue, obviously, with the parent company. The parent company being the defendant, and you have the same corporate veil problem that everyone has of yes. Separation of corporate identity and as the parent as a shareholder generally not being responsible for the conduct of companies in which it invests, and the approach that has been taken in these three Canadian cases, the tort law approach at least, is based along the same lines of direct liability that we followed in the UK cases, I think.
Yeah, exactly. I mean, we borrowed it lock, stock, and barrel. The notion that it's the parent company that has direct responsibility. In both Tahoe and Nevsun, we built. We recognized that was headed for perhaps even a motion to strike the claim as not recognized under Canadian law, as it was in Corey's case in Hudbay. So those motions in Canada are decided on the pleadings without extraneous evidence. So we built the pleading to try and withstand that challenge. And what we did is we focused on the corporate policies, and we focused on, in Tahoe's case and Nevsun's case, their public pronouncements that they had embraced the international standards of corporate social responsibility, which place responsibilities on the board of directors in Vancouver. And so again, this was back to our narrative to build the case about decisions made in Canada, focusing on the authority of the board of directors and their responsibilities. And so we incorporated that very heavily into the case from the outset, and essentially pleaded the UK direct liability cases in the Canadian mining context, where they've all have on their websites public pronouncements of the adoption of these standards, and use the standards to persuade the court that at the root of all of this was a power structure that was centered in Canada.
So it seems to be, I mean, in these cases, it seems to be very much at two kinds of levels, similar to our cases, where you've got allegations about direct supervision and management of security personnel, authorizing them to take certain measures to evict people or to use force against them, or failing to do those things. So there's that kind of at that level, and then, as you say, the public pronouncements and policies at a slightly higher level.
And then I would say, Richard, the other thing we did in Nevsun that I think had a profound impact on the way the case played out is we ultimately sued the chief executive officer of Nevsun personally, Cliff Davis. And Davis was the CEO of Nevsun at the important times, but he also sat as chair of the board of the Eritrean subsidiary. And so we had him in a dual capacity, and we raised a claim against him as both in tort law and in customary international law. And I think that created some very profound problems for the defense of the case. I mean, Canadian corporate law, the state of our tort law is that a director or officer can have personal liability if their own conduct was wrapped up in the tortious event. So they can't be sued simply by virtue of the office they hold, but if they authorize the decisions or their own actions contributed to the tortious conduct, they can be sued personally. And that sends a pretty strong message.
So it's I suppose some kind of assumption of personal responsibility for the conduct.
Yeah. So I think the paradigm example is if you is a case out of Alberta where the senior officers were extremely aware that the company safety policies were deficient, and there'd been multiple warnings, and an individual was tragically injured, and the court said enough is enough. Your failure to act is tortious.
Yeah. Now I see as well in the Hudbay Minerals case that there was reference to, I mean, not just policies, but standards like the voluntary principles on security and human rights, CSR frameworks that the company had publicly endorsed, and that was said to give rise to the imposition of a duty of care.
Yes.
On the parent company.
Yeah. We made very similar arguments. So in Canada, the duty of care analysis is remarkably similar to the UK. We follow a modified version of the ANS case, where we have to establish proximity and which of your neighbors ought to be in your contemplation when you act. And I think Corey Wanless and Hudbay and our team in Tahoe and Nevsun use those standards to demonstrate that it was always in the contemplation of the parent company that the failure to act would harm exactly these individuals that were in proximity to the mine or in Eritrea were conscripted into national service and deployed at the mine. So we use them to really give the court an anchor for the proximity analysis under duty of care to establish the direct parent company liability.
And to date, although these principles of the tort law direct duty of care has been invoked in these cases, you haven't had a decision on duty of care. There hasn't been a formal determination of that yet.
That's correct. I think Hudbay will be the first case at trial to deal with that proposition, rather than on a motion to strike where the hurdle is much lower. Although there are some cases in Canada that have effectively established direct liability against a parent company, but on the facts of those cases and without the deliberate analysis, such as through the Chandler, the Chandler and Vedanta framework.
But it is looking quite promising in view of what the Supreme Court said about the need to have to develop tort law in Canada to cater for infringements of customary international law.
I'm certainly optimistic, and Richard, I can say that even early on, when we were in the British Columbia Court of Appeal dealing with the forum non-convenience dismissal of Tahoe, I was questioned, maybe interrogated is a better word, by one of the panel. One of the appellate judges with strong academic background, who said, this is an aside, but I need to understand this component of your case. What is this allegation of direct parent company liability? So, we laid it out in probably 20 minutes of argument on an issue that was not a decision point in the case, and the reception was rather positive. That that this is that this is doctrinally sound. Because the inverse is not true. Solomon and Solomon, that we all are burdened with, makes no sense at all when you're dealing with the interaction of a powerful corporation and involuntary participants, such as Luis Fernando Garcia really didn't have a say in which of the entities shot him on that day. He's only concerned about which of the entities controlled the events at the mine. So it's always been remarkable how powerful that corporate veil has been, when it's, as we know as lawyers, is not doctrinally sound. We weren't investors in the company. We're not seeking to step around a contractual arrangement by suing someone else. These are, by definition, involuntary interactions.
Yeah.
So
now tell us about the Nevsun case, because we keep
absolutely
hovering around it, but maybe you could tell us about the kind of the facts of the case as well.
So the facts of the case, and I'll stick to the facts as alleged, because as many people know, we've now have reached a settlement of the case, and we are subject to some confidentiality requirements that I have no doubt I will be personally sued if they think that we've transgressed it. But the facts as alleged are that this Vancouver-based mining company, Tahoe Resources, made a find of a significant gold deposit at Bisha in a region of Eritrea, and entered into a development arrangement with the state of Eritrea, in which Nevsun would own 60% of the Bisha mine through a series of offshore subsidiaries, and the Eritrean state would effectively own 40% through something called the NAMCO, the Eritrean National Mining Company. And in the process of developing that mine, Nevsun did absolutely no due diligence on human rights issues. I can say that publicly because they confirmed it in a letter to Human Rights Watch. They simply engaged with local Eritrean construction companies, including a company called Sagan, which is owned by the ruling party of Eritrea. And Sagan has the unfortunate problem of much of its workforce is conscripted labor from the National Service Program. So in Eritrea, you had a system of mandatory national service, which as originally conceived was 18 months, including 6 months of military training. But in the early 2000s, president for life, dictator for life, Isaias Afewerki simply announced that from that point forward, national service would be of indefinite duration. And from that point forward, essentially enslaved the population in a system of indefinite national service that could be either in the standing military or in service of companies owned by the ruling party, and not necessarily even the government itself, but the one and only ruling party. And that system has obviously been criticized by the ILO, by the United Nations Commission of Inquiry into Eritrea as being a system of forced labor. And so the core allegation in the Nevsun case was that individuals subject to indefinite national service were conscripted and forced to work at the construction of the Bisha mine. And we brought a case against Nevsun, as Richard has said, pleading both traditional Canadian tort law, but also raising claims for a remedy based on customary international law, and specifically the prohibition against forced labor, and also the prohibition against aiding and abetting crimes against humanity, which we allege the system of forced labor was but one element of an ongoing crimes against humanity perpetrated by the Eritrean regime against its citizenry. And so I'll just paint through a few more details. As Richard's already mentioned, Nevsun, like most other Canadian mining companies, had pronounced that it was following international standards of corporate social responsibility, and in particular the IFC standards, really the Equator principles. So the IFC standards that they would apply to a privately financed project, and it's there that some interesting things happen. So early on, Nevsun had sought financing from a consortium of European banks led by the DEG out of Germany. And the European banks were quite adamant that an assessment had to be done as to whether the project was in compliance with the IFC standards, and in particular, the prohibition on forced labor. And in 2009, a quick assessment was done in which an expert was retained by the United States and sent to the project. And she very quickly identified that there were conscript laborers on site. And that obviously we became an important event in the case. And the European financing eventually fell through, and the project was then financed through equity investment by BlackRock and by M&G out of the UK. But there was that failure to do the upfront assessment, was a significant part of how we pleaded the case. And And remember, in Canada, a lot of these preliminary issues are fought out before there's any formal discovery in the case. So your ability to bring evidence forward is really limited and requires you to do your own upfront investigation. And we were greatly aided by work that Human Rights Watch had done, which included a rather remarkable exchange of letters in which the CEO of Nevsun frankly conceded that they'd done no due diligence on this Sagan construction company and not investigated its labor practices, nor had they been able to inspect the Sagan camp at the Bisha mine in which the workers were housed to check for the conditions in which the workers were being housed and treated. So, that was pleaded into the case and baked into the case from the very beginning, and I think gave the court some tangible comfort that there's something going on here that is definitely worthy of analysis. That it wasn't just, it certainly was no way a cookie cutter case in which we borrowed pleadings from another action and made vague allegations. The allegations were very direct and targeted.
And the two main issues that were decided in the case is first the actionability of these customary international human rights violations, these fundamental violations against a company, against Nevsun, and the other was the foreign state immunity point.
Yes, the active state doctrine.
Active state doctrine. Well, shall we deal with that one first then? So that's something that we're also familiar with, as you know, with the Belhaj decision, which I think you referred to was referred to in that case. But maybe you could explain how that worked in Nevsun.
Sure, absolutely. So the challenge that was raised by Nevsun was that the claim against it was non-justiciable in a Canadian court, because ultimately the central complaint was that Eritrea, through its system of indefinite national conscription, was guilty of forced labor, and that at best Nevsun was only aiding and abetting it by using the forced labor indirectly at its mine. And so the argument was made that it would not be proper for the Canadian courts to adjudicate the conduct of a foreign sovereign, Eritrea, and therefore it must also be improper for Canada to adjudicate the subsidiary or accessory liability of a corporation arising from the same events. And so they put forward the argument that the entire claim was barred by the active state doctrine. And the active state doctrine had not been directly addressed by the Canadian courts until this point in time. And Richard, again, you're absolutely correct that in defeating active state, we borrowed very heavily from the UK analysis, and in particular Belhaj. And I can tell you it certainly brought me back to law school days of trying to unravel the British approach of concurring in the result, but introducing a myriad of different ways to get there, some of which still confound me. But it certainly brought me back to law school. We were, we were waiting for the UK Supreme Court result in Belhaj with a high degree of anticipation that it could, if it went the other way, really end our case, because active state, unlike customary international law, was an all or nothing proposition for us. Had we lost on it, the case would have ended. And as you saw, 2 of the 9 judges in the Supreme Court of Canada were prepared to end the case, which, to this day I find extremely troubling, because the active state doctrine is a negation of the rule of law. It essentially says that the conduct of this Canadian company is beyond scrutiny in a Canadian court, which is an astounding proposition. So that's active state. The end result is that the Supreme Court of Canada did not recognize the doctrine of active state. So they did not apply the Belhaj approach. They simply said it's an unnecessary doctrine, and that the underlying issues that it addresses had already been resolved in Canada through forum nonconvenience, choice of law, deference to foreign law in the appropriate case, and non-justiciability in the appropriate case. So the Canadian courts, recognize that there are certain types of issues that are not in fact legal issues. So they decided that that the UK essentially decided that the UK Supreme Court analysis was not a unifying analysis that could be put into service in Canada, and that there was no need to try and create the doctrine as a unified approach to what are really diverse problems. So it was not ultimately recognized.
The conclusions that they reached seemed to be along the same lines, even though they said it wasn't part of Canadian law. Because it involved fundamental human rights violations in particular. Because,
yes, exactly.
Because the claim didn't actually allege, there wasn't a claim against the Eritrean government. These are important factors.
Yes, that one could adjudicate the responsibility of Nevsun without directly implicating the Eritrean government. So, yes.
Now, what about the rationale then for when turning to the decision on the application of customary international law to the company? What were the main rationale? What was the main rationale for that?
So we had benefited from a prior Supreme Court of Canada decision, a case called Hape, in which the court had made it absolutely clear that the doctrine of adoption applies in Canada, such that customary international law is incorporated into the law of Canada and can aid in the development of the common law. And so that door was open, and that is the vehicle through which we advanced the case. And we made the claims in customary international law, as I said, because we were advancing an argument that this is transnational conduct, and there are a series of well-established peremptory norms of international law that can be invoked to judge the conduct without, getting into this choice of law issue. And the majority of the Supreme Court of Canada found that a claim could be based directly on customary international law, which is actually a step beyond the argument we were advancing. We were advancing that the court could recognize a tort remedy based on the violation of customary international law. So we were essentially following, what Paul Hoffman had described and what had been in some sense, the American ATS approach, which was the rule was derived from customary international law, but the remedy was fashioned as an act of, if you like, domestic tort law making authority of the Canadian courts as a matter of common law. So, at common law, the court always retained the ability to recognize new torts as required to meet new societal challenges, and we have a framework for the recognition of new torts, which we could fit the case into, drawing on these rules from customary international law. But Justice Abella went one step further and said that in fact it's quite likely that these norms are directly actionable without even having to go through the recognition of a new tort. So that's not something that we'd advocated for. I mean, it's a profound judgment, and the main reason we didn't advocate for it is we were like, we had the internal debate. We are already pushing the envelope on a novel theory of law. So we were trying to make the somewhat contradictory arguments that it's novel, but yet a conservative step in the evolution of tort law in order to fit it within the framework for recognizing a new tort. So that was
just to get it straight. There's two possibilities then. One is that you can directly apply the customary international law principles to the company, and the other is that the court, when dealing with the case, will have to develop new torts to reflect those principles.
Precisely. And the court has left both paths open. And I think Justice Abella strongly endorsed the former as the more direct path here. All based, though, Richard, on the point you'd made earlier, on the need to vindicate human rights and the need to recognize these fundamental human rights as such, and to stop, in my words, is stop trying to view it through the lenses that this is somehow an amalgam of an assault or an unjust enrichment claim. When you have people whose labor has been forcibly extracted from them, you need to call it what it is and to approach it on that basis.
Yeah, I wanted to come back to that point. I'll just come back to that point in a moment. But just before I do, because we're talking about fundamental human rights violations here, this is not an approach that would work in an environmental case, for instance, or a case where people had suffered from occupational diseases at a subsidiary of a parent company. This is reserved for cases of crimes against humanity, slavery, possibly forced labor. That's a question, but torture.
That's certainly our sense, but interestingly, Justice Abella did not limit her analysis to peremptory norms of customary international law. She said it's norms. So it may be that that it's broader than we conceived it. But for instance, we did not make this claim in Tahoe. We did not make the argument that the shooting of the protesters was a violation of a peremptory norm of customary international, in part probably because our thinking hadn't evolved to that point. But also we were wary of overplaying our hand, but we also realized the hand we'd been dealt with was quite powerful, that this was an instance where you could make a profound argument that this was a violation of the norm against forced labor. Yeah, I think you're absolutely right. Our current thinking is still cautious that the next case would be one that involved like violations, rather than trying to use this approach and broaden it initially to cover an environmental case or an occupational disease case.
The point that you made a moment ago about this kind of approach reflecting the true gravity of what has happened and the heinous nature of it, as opposed to common law tort claim, which characterizes wrongdoing in the language of negligence, and can therefore be seen as diminishing what has happened. Is obviously something that has been raised for the last 25 years against the cases that we do, and you can totally see that. On the other hand, I think that I don't know how you feel about this, but my response to that is that that characterizing things in that way legally doesn't stop the facts of what happened from being told, and those facts are always told. And of course, this expressing things in their true nature is only really going to play out if a case goes to trial.
Yeah.
Which is very rare. I mean, the Nevsun case was settled. By and large, these cases are settled, and so it's very unusual to have a trial at which findings of liability are going to be made. So I think that's my response to it. But I mean, it is a point that's made consistently throughout the judgment. Of course, academics and other people will constantly raise this point, which is a fair point.
Yeah, I mean, it was. I think there are some other but salutary effects of that, in that I think it may cause equity investors or other investors to give pause for a moment about. It's quite one thing to be associated with an endeavor that's found to be negligent in some regard, quite another to be associated one where there's a risk of a finding that it is in fact aiding and abetting forced labor. So there's that aspect. But no, I think, look, when all is said, we obviously believe in the power of the tort system itself to find a remedy where the facts so demand. And and that comes through in the minority decision in the dissent on customary international law, where Justice Brown has said, well, the tort system is fully capable of providing your client a remedy. We don't need to go through this exercise. And he challenged us in oral argument on this issue. But my response to that is, well, if the tort system is so robust, how did we end? Look, slavery and forced labor has been with us for a long time, and there hasn't been a powerful response of the Canadian tort system to it yet. So, so I'm not certain that you can say it's up to the task. And there are other features of the Canadian tort system that, frankly, we wanted to overcome. Our approach to damages, in some instances. Richard, there's also a potential impact on statutes of limitations. In British Columbia, we do not have a limitation period for certain forms of sexual or physical assault that arise from a position of vulnerability. So, forced labor could easily fit that. So there were other subsidiary issues that stood to be impacted by that.
That's a good point. That's a good point. Now, you had, in this case, there were interventions from a number of organizations, including, I believe, was it Amnesty International and Mining Watch Canada?
Yes, and the International Human Rights Program at the University of Toronto, and then a mining association intervention, which was, remarkable for its candor, that if we started to rein in Canadian companies and impose this liability on them, they would no longer be able to compete with the Chinese. So they were at least very blunt about it. So,
but on as far as the interventions which supported the case were concerned, how important do you think those were?
I credit, I think they were valuable. I credit our colleague Corey Wanless, because the U of T factum was powerful. I think it killed active state. It just said, this is a complex doctrine that solves a non-existent problem in Canadian law. We don't need it. And and ultimately you can see that sentiment coming through in the majority decision. And we made that argument, but I thought that factum did it in a very succinct way as well, that really reinforced our position. And it is helpful, although they get very limited speaking time. The breadth of interventions, I think, demonstrated to the court that the time was now to deal with this issue and to address it as a human rights issue.
Well, I mean, we typically have interveners in our cases when they get to that stage. But I mean, it was interesting looking back at Paul Hoffman's talk in December, the number of interventions that there were in the Nestle case in the Supreme Court. I mean, there were lots from a whole variety of organizations.
Yeah, and I think we were each party to the international lawyers brief, which I think even got some play in oral questions. So that's it's powerful. Now, I would say, Richard, I mean, in our case, there was no need to have an intervener brief from yourselves or UK lawyers, because British law is fully understood in Canada. We can simply argue the cases as we did without need for an intervener.
Yeah, quite, yeah. Look, I'm sure we've got some questions, but there was just one other area that I wanted to ask you about, because it's something that you will have to grapple with in the same way as we do over here, which is just being able to undertake the risk of these cases, to fund them, and the difficulties around that, and the financial viability of cases. I think, as I understand it, in Canada, you would work on a contingency fee basis, so you get a percentage. Your financial recompense at the end would be a percentage of the damages, which means, in a case that goes on for years and requires a huge amount of resources just to break even. The value of the case, the financial value of the case would have to be high.
Yeah, I mean, it is an extremely serious issue, and I don't think there's any coincidence that there's only 3 of these cases in existence in Canada at the moment. They are a massive burden on your firm, and you have to do them, in our case, with a full expectation that we may never be compensated for our time. And so we took that risk, and I can say we did it for all the right reasons. We'd had a good run of it as a firm. We'd had a successful practice, and my partners and I were at the stage in our careers where we felt we could afford these risks, and there were profound reasons to take it on, and so we simply did it. But in the process, we are hoping that by having defeated some of these preliminary issues, we've greatly reduced the cost and risk and burden of the next cases. And that's all that we can do. But, I think we still find that there's probably only a handful of firms in Canada that are even prepared to contemplate a case like this. There might only be 3 of us. And they're probably all on this on this webinar with us. It's troubling, the cost of the system. So
I can totally identify with that. The kinds of firms that have the financial wherewithal to take on this kind of risk are the firms that represent the corporations and would be conflicted out from doing it.
Yeah.
So you have a few organizations who can just about do it, perhaps like your firm and ours. But it is a big risk. And the point you make about the importance of breaking down legal barriers, is critical as well, because as you say, when you break down a barrier, you're reducing the risk the next time. If you get over forum non-convenience a few times, then you can do it. It's not such a risk.
Right. And I guess I would add this, Richard, to come back to our point about why was the claim of customary international law broad and what its significance. Tort damages in Canada are constrained. The amount of compensation you can get for non-economic or non-pecuniary loss is constrained by a court-imposed limit of about $330,000 Canadian reserved for the most catastrophic cases. But charter damages are unconstrained. So where the government of Canada violates your human rights, the exposure can be quite significant. And in the majority decision of Justice Abella in the Supreme Court of Canada, we find the same language used as in the charter cases. So we achieved our goal of opening up an approach to damages that was unconstrained, which meant that if we proceeded to trial, the defendants would have no way of calculating their risk and containing it. And that's very powerful, right? Because if we were constrained by ordinary negligence, the defendants had a pretty good idea of what their maximum exposure was. And that was an important, probably a hugely important finding, that we can vindicate these rights using a different lens, which is the violation of constitutional rights, and open up the damages to something, profound.
Is there any prospect in these cases, you think, of litigation funders backing them?
I don't know. We've stayed away from that. I would say, as later in the case, we got some valuable assistance from Freedom Fund for some of the issues we were engaged in, really in dealing with the individual clients, which, I have to note, continues to this day. A number of our Nevsun clients are trapped in the conflict in Tigray in northern Ethiopia. They were in refugee camps, which they've now fled, and we are still working with Freedom Fund on trying to get them out of Ethiopia. So, but traditional litigation financing, I suspect that had we gone to them in the Nevsun case at the beginning, they would have been shocked at the degree of risk. So,
yeah.
But as you said, is the more that this becomes a conventional path, the more likely that other options open up for funding them. Absolutely.
Joe, we're going to move on to questions. I just need to look on my phone to see. There have been a few questions, and the first one, which actually came in before we started, was from someone called Sarah Palacios, who's a PhD student at Nottingham University, and what she asked was that she refers to the frequent references in the judgment to slavery, allegations of slavery rather than forced labor, and she wants to know on what basis you concluded that the threshold for slavery had been reached.
Yeah, excellent question, Richard. I mean, to be completely blunt, it's probably more in the area of advocacy that we were drawing a direct line from the, one of the origins of customary international law being the prohibition against slavery, and the fact that those norms could be applied to non-state actors, and linking that to modern forms of slavery and forced labor. So the terms ultimately became used interchangeably in oral argument, but certainly there's no assertion that this is chattel labor, chattel slavery. We never a suggestion that the state of Eritrea owned these individuals. I think the argument was made that it was forced labor akin to slavery, in that there was evidence that for some of the conscripts, the control over their autonomy was near absolute. But the question's quite right. There is a legal distinction between slavery and forced labor, and we blurred the lines in argument intentionally. But in order to draw that arc from one of the branches of customary international law and its application to slavers to a modern context.
There's a question for me, actually. How can Nevsun be used in the UK courts? And from some discussions that we've had about this, I think we're not confident that the UK courts would be as positive about this as the Canadian Supreme Court. One reason, I think, is that there has not been an application of our Human Rights Act against corporations. And so the concern would be whether, when you're talking about customary international law, that would there's any prospect of that being applied against a corporation, that perhaps it might be more feasible where you're talking about accessory liability rather than direct liability. But
yeah, and Richard, I do think that our own court's experience with our Constitution and our Charter of Rights has changed the judicial dialogue around human rights, and you can see in Justice Abella's decision that parallel between vindication of charter rights and vindication of fundamental human rights. So that may be a significant distinction between the Canadian legal culture now and the UK. I don't know.
There's another question. I don't know who it's from, but to what extent is it frustrating that these cases do not go to trial, meaning that the law on the full facts is not settled?
Well, it's the bitter. I would say, Richard, the hardest part of being a litigator is that you have these conflicting challenges of wanting to bring it to trial and get the full benefit of a trial finding, with the competing obligation to find a remedy for your client. And sometimes the course of action you're required to take is to resolve it, because that has a profound impact on your client's rights. And of course, you know, it's so it's profoundly frustrating. But we live with it daily, not just in this context, in the context of all the tort cases we do. It's a challenge.
I agree with all those points, Joe. I think the other point to make is that the Nevsun case itself demonstrates the value of bringing a case and the benefit that it can have in the future, even though it doesn't go to trial. I mean, this, you know, and we've seen that with so many cases. Look at the Vedanta case in England.
Yeah.
So just because a case doesn't go to trial doesn't mean it doesn't achieve benefits, important benefits. But I agree, you know, I agree with everything else you said. There's the next question. If Nevsun was an English company in the case brought, right, so I think we've spoken about that. Then there's a question from one of my colleagues, Leo Gonzalez. If an environmental case deprives the claimant from fundamental human rights, e.g. a massive oil spill which deprives the claimant from his livelihood, little food, to the point of gravely affecting his health, it could attract customary international law, couldn't it?
Yeah, absolutely. And I can say that we've, again, Richard, we've had that exact discussion in our firm about the implications of that. But it certainly could.
Okay. Now this question from Malcolm Ruggie. Are recent developments in the UK duty of care cases, Robinson, good or bad for transnational tort litigation of this nature? I think someone's going to have to help me out because Malcolm, I'm afraid I don't know the case of Robinson. But Joe, there's a question for you. What kind of doctrinal pushback might emerge in Canada?
Yeah, I think it's an excellent question. And it goes to a comment you made, Richard, which is where to next? So if the next case is an attempt to shoehorn a set of facts into a violation of customary international law that's not a good fit, we definitely run the risk of the doctrine being narrowed before it's even really given full birth. So, you know, that's a concern. I think the fact that it was a 5-4 decision of the majority suggests that you could easily get doctrinal pushback in the lower court based on the dissent. Although I'll personally say I find the dissent not particularly persuasive and internally inconsistent. It's there to be reckoned with, but I think the real issue is what is the next case? What's the next evolution in the doctrine? And is that, you know, is that a case that it's profoundly obvious that it's a violation of peremptory norms of customary international law? Yeah.
No. Let me see if there are any more questions. Final questions. There's 3 questions. First question is, for a host state mining company or investor, what would you counsel them to worry about, given the intricacies or idiosyncrasies of home state jurisprudence? For a host state mining company, state or investor, what would you counsel them to worry about, given the intricacies or idiosyncrasies of home state jurisprudence?
You know, I think I have the question. I tell them the rather odd. I'm very blunt, which is, you know, do not aid and abet violations of fundamental human rights norms. I don't think it's intricate. That's the point I've been, you know, tried to make in the courts. The standards are actually really quite clear, and what we're trying to do is give teeth and a remedy to the violation of these standards that are out there. So. You know, the answer is that you must do a full human rights impact assessment, and you actually have to seriously, eliminate those risks and mitigate those risks. But Richard, I think you've had some experience that we haven't, where there's been an attempt at that with a very incomplete, inadequate, in place system for community engagement or redress.
Yeah.
Yeah,
I mean, certainly, the days of hiding behind the corporate veil are past now.
Are gone. Yes.
Are gone, and not only that, in the current climate with standards like the UN guiding principles on business and human rights, and corporations being required by their investors and financial backers, and when they get loans and loan guarantees and so on, to comply with proper human rights standards across their business operations. It's just not possible to escape from this. And companies are obviously also concerned about reputational consequences. So there've been cases. Yes. Some of our colleagues have done cases recently involving supply chains which end up in UK retailers, and the damage that can occur if a company doesn't exercise proper human rights due diligence across its business operations. I mean, is huge. So unless you don't care about your reputation.
Yeah, then, I agree with all of that. Right.
So, well, I think we've come to the end, Joe. And look, I just want to thank you for this fascinating discussion. And I'm sure you've inspired a lot of people, not just with the work that you and your colleagues have done, but with your presentation today and your explanation, and just the obvious joy that you gain from doing this work, which is a pleasure to see. So I'd like to thank you for taking the time to talk to me today and to share all your thoughts with us. And I hope everyone who's been listening has enjoyed it as much as I have.